Good afternoon, everybody, and welcome to this Eversheds Sutherland webinar on coronavirus, hoping to give insights and practical solutions for landlords. My name is Caroline Andresier. I am the professional support lawyer to the real estate practice group here at Eversheds Sutherland. I am here in our London office with Bruce Deer, who is our head of our London real estate team. Good afternoon, Bruce.
Good afternoon, Caroline.
And we are also joined by David Jones and David Feist, both in our Birmingham office. David Jones leads our Birmingham real estate transactional team, and David Feist is one of our real estate litigation partners based in Birmingham, to be known for the purposes of this webinar as Dave J and Dave F. Good morning, Dave. Good afternoon, even.
Hello, good afternoon. Good afternoon.
Right, some housekeeping before we start, if I may. Everybody is on mute. Because there are lots of us on the line and the background noise can be disturbing. Just because you are on mute, though, really doesn't mean we don't want to hear from you. Please just use the chat feature to drop your comments and your questions as we go. You may choose to share those with everyone, or if you go to the drop-down box, you can choose to send them just to me, Caroline Andresier, and I will field the questions and comments to our respective experts. The form of this afternoon session will take a short presentation from each of our speakers, and then we will go on to take your questions and comments. We do commit to finishing on time within the hour, so if we don't get to your question, or actually if you have more questions after the event or follow-up issues or anything like that, the last slide will be our contact details, so please feel free to get in touch with any of the four of us or your usual Eversheds Sutherland lawyer. We are all working, most of us remotely, from our kitchen tables, our dining rooms, or one partner gave me a tour of his utility room office, which was very sophisticated, but we are all still here to help our clients, if not thrive, at least survive the present situation. We are talking today about principles and possible solutions, moving from the what if to the what nows in these extraordinary times. But please remember that as lawyers we cannot advise in a vacuum, and if you have a particular issue, we would always need to read the small print, so please get in touch with one of us or your usual teams. So I will just run us through the agenda, and then I'll hand over to our first speaker. So Bruce will talk to us on where we are now. Dave Jones and Dave Feist will both talk about transactional and contentious issues, and then I'll move on to logistical challenges, how we actually get documents produced and signed and registered in these extraordinary times. Anytime you want to raise a question or a comment, please just drop it through the chat feature. So either do that as each of our speakers go, and I will field questions at the time, or else I'll call for questions at the end of my slide at the end. So I'll hand over now to Bruce.
Thank you, Caroline, and good afternoon, everyone. I think we need to begin with an honest and evidence-based assessment of the situation that we and our market find ourselves in. Now, a few people are still saying that all this C-virus stuff is overblown, that property is just a cyclical business and things will pretty soon be back to normal. They're almost certainly wrong, sadly, and worse, they're suffering from a gross failure of imagination. Downturns come and go, but this COVID-19 crisis, though hopefully reasonably temporary, is of a completely different nature. This is not a downturn, it is a full-scale economic and social shutdown, and though temporary, it is likely to last, unfortunately, several months. Now, in a downturn, people keep spending. They go to pubs and restaurants to cheer themselves up. They work together in offices and factories to find productive ways round their problems, and they travel long distances to solve them. Many of us have been through downturns, in my case in the 90s, in the very early noughties, and again in 2008. But compare COVID-19's impact to the nature of those downturns, and you will see that we're dealing with a completely different enemy. Since January, US flights to Asia are down 98%. And they are down 37% to Europe. The FTSE is down 34% since January. And UK restaurant bookings are down 82% year on year. And even gold is falling. Yes, even the price of gold has started to fall in recent days, and that's because investors believe there is no pure safe haven from this all-pervading crisis. And in some ways, COVID-19's impact is worse than an external war, because even during a big external war, demand and production surge, and people are working hard, and the economy becomes very, very active. COVID-19 is much bigger and more threatening a challenge than the Blitz ever was, and this is not in any way to belittle the horror of war or the heroism that people showed in the Blitz. It's just to emphasize how utterly unprecedented the COVID-19 crisis is. What does this mean then for the real estate market? Well, I think a global challenge of this scale requires a grand, generous and visionary response. Yes, we should all know our rights and be ready to sue and defend ourselves if we are sued, but we need much more than that, much more than just an individualized, siloed landlord against tenant and rights-based approach. That is wholly inadequate to this situation. If we simply go down the sue and be sued route, as though this is an ordinary downturn, like say the property crash of '89 or the dot-com burst of 2000, we will turn COVID-19 from a temporary crisis into a permanent and mass destroyer of value and solidarity in our industry. Now, usually in a downturn, landlords and tenants fight about service charge, fight about rents, and tenants try to reduce their liabilities by exiting their premises through assignment, underletting, or by exercising break clauses. Now, unusually, assignments not underletting won't be available this time because for at least the next 3 to 6 months, there will be no market to assign or underlet into because people are not going to inspect buildings, they're not going to go in to value them for at least the next 3 or 4 months. And if there is too much fighting, only COVID-19 will win. Remember, this crisis is a shared problem. Tenants have obvious revenue and business continuity issues immediately, but not all landlords have deep pockets, and even those that do have duties to their shareholders, investors and pensioners. So it's a question of striking the right balance together. So we need to work together as an industry to produce sustainable solutions. We need to talk to each other constantly, both tenant to landlord and through our industry bodies. And we need to act on an open book basis and constantly look for compromise and share burdens. We need to work together as an industry as we would in wartime to solve this problem and to come through this dark tunnel together. When we actually do document the agreements between us, we need to make sure they don't breach our obligations and relations with third parties or cut out potential government and insurance help, which I think must be on its way. Solutions need to be sustainable and repeatable. The Prime Minister has said we can turn the tide in 12 weeks, meaning the infection rate will have peaked by then. But if COVID-19 behaves like other viruses, for example, the Spanish flu of 1918, we could also see a winter spike, albeit that the government's policy is designed to flatten that spike down. So we must plan, I think, for at least the next 3 quarters' rent to be materially affected by this crisis. And we ought to be looking together at rent forgiveness, forbearance, deferral or conversion of rent, and we need, as we do so, to get third-party consent and buy-in from our landlords, from our mortgagees, and so on. We need to also make sure that the integrity of any rent review, insurance, or potential government protection or underwriting is not compromised by the way we give any concessions or any postponements of rent. And we need to preserve service and insurance charge. Of course, we may adjust for building shutdown and reduce services, but we need to keep those buildings good for when we come out the other side, which we definitely will. And finally, on a grand scale, all key landlord and tenant bodies should form a grand war committee to agree a comprehensive policy across our industry for COVID-19. And they need to lobby government for action this day, something that Churchill used to write on memos in the Second World War. Now, Churchill is Johnson's hero, and he needs to start acting in just that way. Rents and wages must be underwritten by the government, and COVID-19 related losses compensated. The government needs to move to a more interventionist war footing to help our industry and all the others. During World War II, the government set up a War Damage Commission to compensate businesses for war-related losses and to ensure the economy came through its greatest ever challenge until now. Our industry needs to lobby for just such an ethical response today. But vision is not enough if the other side don't share it, and landlords and tenants must know their rights and how to defend them.
Thank you, Bruce. So, as I said, that's where we are now, not where we want to be. But the 2 days will now talk us through some transactional and contentious issues that we are facing in situations right now.
Thank you, Caroline. So, hi, I'm David Jones. I'll deal with the first 2 points on this slide and David F. the second 2. The first point, new build, that's really a point about build periods for development schemes or reconfigurations that we're either about to start or we're already working on. So typically, developers' work to landlords have to be carried out by target timescale, which is subject to delaying factors. Those delaying factors normally mirror the building contract as a minimum. Quite often we get extensions on top of that, whether that's force majeure, events outside the developer's control, maybe even, in more recent times, contractor insolvency. So the first question is, will the coronavirus allow an extension of time under those contracts, assuming they're now live? Well, I suppose there's an overall answer, probably, but not always. Certainly when we're dealing with force majeure definitions, ironically, the wider the list of items within it, the worse it would be, because the courts assume the parties have thought of all the circumstances that they ever would need and have agreed that limited list. So first point, where there are live agreements, check out those listed delaying factors. More importantly, the long stop date, because those agreements will always have a long stop date. Traditionally, it's double the build period. Those long stop dates very, very rarely extend, so those need looking at in light of where we are now. The second point, time resilience, that's really more about conditionality. So those kind of development deals will be conditional on various things. The most obvious one is planning, getting planning. Well, in the world we are now, can we rely on the council's planning teams complying with any timescales, never mind reasonable ones? Will planning committees even meet? For price-related conditions, there'll be jobs that may be out to tender now, but frankly, no one has any idea what contractors are going to come back with by way of pricing or risk mitigation or even hard dates they're willing to live up to. Where we've done larger regen schemes, it's very usual to see a viability condition in there. Effectively, that's the last condition, and I think we're going to have to start looking at requiring those in developments of any size, really, any decent size.
Thank you, David. This is David Feist speaking now. Just looking at the position on insured risks and uninsured risks, I appreciate most people on this call will be aware of this already, having been frantically checking these provisions over the last couple of weeks. But the starting point for insured risks and obligations for landlords to insure is, of course, physical building damage. Therefore, the scenario that we are faced with at the moment, where, for instance, a centre may be closed, or we'll come on to that in a moment, or a retailer may not be able to operate because of other chronic shortages which are brought about, is not something that is covered by the insured risk that a landlord undertakes in most institutional leases. So that is a very important point, and there are a number of things which flow from that, and in my view flow directly into the very unfortunate situation we seem to be facing in the short-term future around closing a scheme and building closure. Well, there are a number of different scenarios that are coming into play now and which may come into play in the future. So, for example, we had an announcement by the Prime Minister and the Chief Medical Officer recently recommending that pubs, bars and restaurants close. Now, my view, and this is one that we've considered quite well, it's inevitably high level, but where we are simply faced with a recommendation that something does not operate, then where does the risk fall there? If the tenant decides, in light of that recommendation, to proceed to close a particular outlet, then they would normally be carrying the risk there. Because there may, for example, in a keep open covenant, be a carve-out that the tenant does not have to keep open in the event of an order or direction of a competent authority. But where we are only dealing with recommendations and a decision is made to close a particular outlet, then the risk there is carried by the tenant, in my view. There is no suspension of rents because that is always inevitably tied to the building not being capable of occupation as a result of insured risk. Similarly, landlords' obligations in this respect in terms of whether they make a decision to keep open a particular scheme and their obligations contained in covenants not to derogation from grant, quiet enjoyment, and to provide services, some of which we'll come on to in a bit more detail later. If a decision is made to cease providing services and effectively close down a scheme without the direction or order of government, then that is a more vulnerable position for a landlord. I mean, all this ties back to Bruce's excellent introduction, which is, if we all look at this from a purely rights-based position, the outcomes don't look particularly good for landlord or tenant based on the typical covenants and obligations that you will find in most institutional leases with which you will be familiar. Can I hand back over to you now, Dave, please?
Have the next slide, please, Caroline. By the way, apologies if you can hear any background noise. The building next to us is being redeveloped, and they've obviously got a very narrow definition of force majeure in their building contract. So, few items. So, we could look at any of these sectors, but particularly wanted to look at the legal aspects rather than the effect on markets. So, retail and leisure first. Now, clearly, this virus has obviously hit hotels and other leisure uses and physical retail hard, effectively those uses that rely on people acting like human beings and being social. Now, some landlords already use turnover rents as rental top-ups or as rent ratcheting models, like we see in outlet schemes. We presume tenants are going to want to make that linkage even greater. We've seen in the press this week, H&M have been very vocal about stating they're looking to go turnover only. Personally, I think that's a dangerous move for the landlord community. Turnover calculations can sometimes be a bit opaque, and revenue can be moved to the online channel, which often isn't properly captured. So without a base rent or a landlord ability to break, like in the outlet schemes, if the rent's not acceptable, the rental stream isn't secure. At the end of the day, landlords are providing their tenants with buildings, and that has an intrinsic value, which is the base rent. Office leases. So the biggest disruptor to the office market in the last few years has obviously been co-working. It's the same planning use as traditional offices, but the leases look different. Much looser controls on sharing occupation, underletting, and the rental model is often different and looks at profit share or profit share gearing. You've got to query, though, is this virus an even bigger disruptor to that market? At the end of the day, we're all taking part in the biggest home working experiment in history. Once we get through it, which we will tenants think, hang on, the alternatives do work? Will they require as much space as they did? And importantly, will they want to use it in the way they often have? Will tenants require more flexibility to underlet and share their buildings going forward? The next item there, rent suspension and breaks. So we're all used to rent suspensions for insured risks and in the last 15 to 20 years at least anyway, uninsured risks. Tenants, by the time we get through this, will have now experienced a circumstance where it's almost impossible for them to trade, but they're still legally obliged to pay rent. notwithstanding whatever deals they manage to cut in the next few months or weeks. You'd think, as a risk mitigation measure, tenants of multi-occupied buildings or centres will start asking for rent suspensions or abatements or some kind of pain sharing where the building or the centre is closed for public health reasons. Query, will that also be the case of tenants of single-let buildings? Don't know. Break clauses have been a fact of life in most asset classes for years. I think we might start seeing them where an occupier has been unable to occupy a trade for a set period of time, or even a landlord break where the tenant's rent suspension has been longer than a set period. I just think these things will happen. We, as an industry, will need to land on an acceptable compromise that works for everyone, much like we did for uninsured risks those 15 or 20 years ago.
Thank you, David. Just to talk about landlord services, we all know that this is effectively about complying with our obligations to provide services which are in the leases with our occupiers, and it's about keeping the scheme open. There are one or two basic points that we've been asked, which you don't have to be a rocket scientist to answer over the last couple of weeks. For example, some additional cleaning costs that may be necessary. All of those would be expected to be recoverable through most service charge provisions. In terms of a landlord's obligation to provide services, we would find typically that where the provision of services is prevented for reasons beyond a landlord's control, that there would be a carve-out. So if there is a direction or an order from government to cease providing services and effectively close a particular scheme, then that would be an obvious candidate for a carve-out from that obligation. In terms of tenant insolvency, we could have a whole separate webinar about tenant insolvency, but I'll keep it fairly brief. We, of course, at the moment, have a number of existing CVAs that are in place. I looked at a couple of the CVAs, which many of you will have had the misfortune to come across over the last 18 months. And I'm actually looking at the Debenhams CVA as we speak. This will not be untypical, and I expect will be in most of the other CVAs. CVAs allow the supervisors, the insolvency practitioners and the company who propose them effectively, to make immaterial, minor changes. There's already a power in those CVAs to vary them. Material changes, say for instance somebody who's already on a reduced rental payment and want to revisit existing CVAs, would need to, this is the starting point, but they would need to go through pretty much the same procedure that they went through in the first place to pass the CVA, namely 75% of creditors to approve that by value. So it may be that existing tenants who are going through a restructure and who have in place CVAs already may approach the way through this by way of seeking a formal variation and changing and softening the terms even further. If a CVA fails, again, I've liaised with some of my restructuring partners about this. If a CVA fails, the most likely commercial outcome immediately would be an administration, but there is nothing to stop an entirely fresh CVA being proposed. So if a CVA fails or is terminated, there's nothing to stop the supervisor in that company proposing a new one as soon as possible. That's it from me around landlord services and tenant insolvency. I'm going to hand over to Caroline now, who's going to talk about some of the logistical challenges, and then look forward to hearing any questions you've got on any of the areas that I've been talking about later on. Thank you.
Thank you, David. If you would like to start sending questions through or add your comments further, we've had some through on the chat box if you just want to send them through to everyone, or as I mentioned, you can pick my name, Caroline Andresier, out of the drop-down box and send it privately, and I will field those questions to our speakers when I have covered my logistical issues slides, but perhaps you would like to take the time while I talk to marshal your thoughts and send through your questions. So, logistical challenges. First of all, document production. So if there is a deal to be done, if there is a compromise to be arranged, if here's hoping there's actually an exchange or a purchase or a letting to complete in the next few weeks, what about the actual document production that'll get that over the line? We have to split this into two scenarios. First of all, the situations where we can only work with hard copy original documents with wet ink signatures, and every other scenario where an electronic document, electronically signed, will be acceptable. Just because we don't doesn't mean we can't use electronic documents and electronic signing for a lot of real estate situations. We are traditionally paper heavy and deeds based, but for a lot of what we're doing now, we can just use an electronic soft copy document electronically signed. So I'm thinking concession agreements, agreements for lease, even a majority of deeds can be electronic documents electronically signed. That can be a PDF, that can be a Word document. You can assemble your PDF lease and plans and annexures. That can be your document, simply the one on screen. Hard copy original documents are used and needed in just very limited circumstances. Documents that have to be registered at the land registry as dispositionary documents, so here we're talking transfers or leases or charges, have to be wet ink signed originals. Now, the land registry cannot do anything about this at the moment. I think they are showing some embarrassment at rather being behind the curve. But whenever we ask them about being able to switch from wet ink signatures, their standard response to date and up to the point of this crisis has been that it would take primary legislation to allow them to change the land registration rules. So at the moment, we are stuck with needing hard copy, wet ink signed documents for transfers, leases and charges. But for everything else, a rent deposit, a short-term lease that won't be registered at the land registry, concession agreements, rent review memorandums, agreements for sale, agreements for lease, whether they're deeds or not, can be soft copy documents. That'll help a lot. Fortunately, when it comes to hard copy documents, Eversheds Sutherland has a network of local offices, and I'm hoping that plenty of you have nationwide offices too. And maybe documents can't be produced where they normally would be produced, but maybe a colleague will help. We're lucky that actually we're being able to send printing, for instance, requests and courier requests across our network. So it may be that we won't be producing documents and engrossments where we normally would, and we'll be calling in favours, but that has got to be something to look at for everybody. Then it comes to actually signing methods. For those documents that can be electronically signed, electronic signatures, there's been a great deal of interest around the more formal platforms such as DocuSign and others, but an electronic signature can take many forms. If you type in your name, if you use the pen feature and swipe on screen, if you click a box saying I agree, all of those will amount to an electronic signature. The Law Commission published their report on electronic documents and signatures back in October last year, and quite rightly made the point that a signature is simply a party's intention to be bound. It is a way of showing that you mean to be committed to that document, whatever form that takes. So that should give us some comfort about electronic signatures. When it comes to wet ink signatures needed, perhaps it's a question of widening the pool of signatories who can do this for your organisation through perhaps powers of attorney. If your directors go down sick or if your directors are not easily accessible, then actually a power of attorney down to your asset or managers or the next layer down may be the way to go ahead. You widen your pool of people who can apply the wet ink to the document. So that is one solution that we would suggest, that widening your pool of signatories. It's important to remember, though, that the signing rules and execution rules that we have been always abiding by still apply. If you are electronically or wet ink signing a deed, that does have to be witnessed. And that does mean that the witness has to be physically present when the signatory signs the document, whether electronically or by wet ink. The signatory and witness have to be together. You cannot witness a document by Skype or FaceTime or something similar. You have to be physically present. In these extraordinary times, we may take a witness who is a family member. We would normally look for an independent person, but actually, apart from in a situation of a will, there is nothing to prevent a family member bearing witness to a signatory's signing, so that may be a way of getting around that issue of having somebody in the same room. Alternatively, if you have, say, two directors signing on behalf of a company, those two directors do have to sign the same document, but they do not have to be together when they do that signing. So if you're struggling to find a witness, an alternative may be to use two authorised signatories, two directors instead. That might help. Just a quick word there too, if you have a limited pool of people who can sign, and plenty of our landlord clients are funds, depositories, and they use nominee companies to hold their assets, it is usually a requirement that the buyer, say, will require that two different individuals sign for those two different nominee companies. Even if one person has been appointed attorney for both of those nominee companies, in order to overreach the beneficial interests underlying that legal title, it should be two different people signed. So that's a bit of a techie anarchy argument, but you may be faced by a requirement from a buyer to actually have two different individuals, even if one person can sign for both nominee companies. So that's when it comes to signing. Then we come to exchanges and completions and registrations. It's important to realise that when we look to exchange or complete a transaction, exchange a contract or complete, that the documents have to be under the control of a solicitor. When we exchange contracts for you or when we carry out a completion, we are using Law Society formulae for exchange or the Law Society code for completion by post. And inherent in both formulae and code are significant and several professional undertakings given by solicitors. And we rely very much on those professional undertakings to make the world go round on the mechanics of conveyancing. I promise I will send you the documents, you promise you will send me yours today, I'm holding the transfer to your order, all that kind of thing is important. So we still have to abide by those exchanges and completions, and the documents have to be under the control of a solicitor. That doesn't necessarily mean that they have to be in the possession of a solicitor, but they do have to be under the control so that the right undertakings can be given. And then following getting something over the line, the usual registrations, those rules have not changed. You will have to pay your SDLT within the 14 days. You will have to register at the land registry within your priority period. Fortunately, those, of course, can be done entirely online, and therefore I'm hoping that we won't see significant disruption on those. Okay, so that's logistics from me. Shall we turn to the questions that we've got? If you want to continue sending through, I will lay off the questions to our speakers and pick up your questions as we go. So a question, I think, probably for the two Daves to take between you. Could we argue in any way, could a tenant argue in any way that force majeure to terminate an existing lease? And actually in this question, if disease is defined as a force majeure, do we think that that could be used to terminate an existing lease, which unusually has a definition of force majeure in it, and then unusually even includes disease as a ground for force majeure? Dave F., perhaps you might like to take that question.
Yeah, no, thank you. So, as you touched on already, Caroline, if there is a specific clause in the lease which allows a tenant to terminate for force majeure, and that includes disease, then the answer would be yes. But I would expect that to be exceptional, extremely exceptional. And just to sort of amplify and explain my answer there, there's no generally implied term in the law in England and Wales that allows a concept of force majeure to invade the contract and absolve a party of their responsibilities. Force majeure, although I appreciate it finds its way into many contracts, in particular construction contracts, it's a French civil legal code concept. So unless it's been specifically incorporated into the lease, then force majeure arguments as a sort of generic point do not bite. And then just by way of further amplification, if what people are getting at or worrying about is a concept of frustration, which is a recognised English law concept, the the bar for that is extremely high. There's been recent cases, many of us will know, the European Medical Agency tried to get out of its lease of prime office space in Canary Wharf by arguing that as a result of the UK leaving the EU, the contract had been frustrated. But frustration, very narrowly drawn, very high threshold, and basically requires you to prove that performance of the contract permanently has become almost impossible. So unless there is exceptionally a specific force majeure clause which allows a tenant to terminate, then I don't think they would be able to. Hopefully that's a fairly unequivocal answer, but happy to take ancillary points on that.
I think I just add a point to that really, which is, you mentioned, David, it's the ability to do it permanently. So you might see arguments of frustration in the case of very short-term occupation.
Sure.
So if it's a 1-week license to occupy somewhere,
yeah,
and
sure,
somewhere is going to be shut for a year, you can see how an argument might be raised there.
Yeah.
Okay, thank you, the two Daves. Bruce, a question for you. I've got a question from a landlord who's obviously got a European-wide portfolio, asking if actually the issues are the same across European countries, whether landlords are in just the same situation, whether tenants are better off. I don't know what our European colleagues have been saying about this in the real estate sphere.
So we've been advising a number of landlords with European portfolios, and obviously one has to check the law and advise on the law on a jurisdiction-by-jurisdiction basis, and we've got offices in each of the major European jurisdictions who can do that. In essence, European codes tend to be more protective to tenants. European leases tend to be shorter, they tend to be index-linked, they tend to be easier to break, and often the statutory codes that govern them do contain force majeure or similar clauses to bring them to an end on the tenant's behalf. So check it jurisdiction by jurisdiction, but you may find that things are friendlier and easier for tenants in those European jurisdictions than they are on this side of the channel.
Thank you, Bruce. One for the 2 days as well, I think probably between the two of you. We have a landlord who says that they have been written to by a tenant just unilaterally to say that they are now going to pay their rent monthly. It seems there's not been much discussion around it, but just a unilateral movement towards monthly rent. Is a landlord bound to accept that? Have you seen much of that?
Well, yes. I mean, that's not a new thing. Tenants quite often have done that over the years when they're in financial difficulty, and they obviously try and express it as a this is what's happening, take it or leave it. But you can't unilaterally vary a lease, obviously. A landlord can make concessions or sort of waive or defer or those kind of things, but it's not obliged to do so. That's really a sort of a, going back to what Bruce said at the outset about working together, it's that kind of approach. But certainly no one party can just vary the lease unilaterally, whether it's a tenant or a landlord.
Yeah, and just so this cropped up for a client the other day where someone had said, well, I'm not going to pay the full quarter. I'm just going to pay the month of March. And if you accept the money that I send you, then you're agreeing to be paying rent monthly going forward. That is not a concept which is recognised. It's the unilateral point that Dave's emphasised. You can't give somebody a kind of unless in correspondence and vary the contract. So the position there would be analogous to what would happen now if someone owed you 150 grand, they only paid 50, then your rights under the lease in those sorts of circumstances would subsist. But obviously, just touching on Bruce's point earlier, if we all take a very unilateral, rights-based approach to this, then the outcomes don't look particularly good for either party. But you can't unilaterally just require your landlord to accept monthly rent. That needs to be done consensually.
And just picking up on what Dave is saying there, I think it would be very disappointing, although it may well happen, if tenants club together to go on rent strike or simply come in and headbutt the landlord and say we're not paying the rent, because that seems to me to be not the way through this crisis. The way through this crisis is to speak openly to each other, and to try and obtain a sensible, balanced agreement as to the way that everyone can survive and thrive in the longer run. But doubtless we will see some disappointing behaviours on both sides, and they'll just have to be managed as they come up.
Okay, thank you. Another question we have here. As a landlord, what duties do we have to our occupiers to keep their staff safe? We've seen a lot of people take proactive, preemptive measures. Are landlords actually obliged to take that into account? If one of their staff members, for instance, tests positive, should they then be saying to their tenants, you know, all out while we deep clean? What duties do landlords actually have to keep their occupiers safe?
Yeah. Well, if there is a actual or suspected case of COVID-19 in a particular scheme or identified in a particular scheme, I'm shooting from the hip here, but I say it with quite a bit of confidence. I think that the landlord's obligations would extend to undertaking a deep clean, and we've seen that happening. You know, temporary closures or suspensions for a deep clean. Of course, there's all sorts of potentially competing or at least overlapping duties going on here. As a landlord, you have to be mindful, and I'm not an employment lawyer, but you have to be mindful of your duties of care to your employees and people who are at the scheme who you employ. Similarly, occupiers, whether they be office occupiers or retailers, will I'm sure be keen to fulfil their obligations to their employees. I don't think there's a general duty of care to do a particular thing in those circumstances, but you've just got to provide for as long as you can the services. And my view would be that that would extend to, for instance, undertaking some kind of clean if there was a suspected case.
Yeah, if you think about a multi-let office building, for example, the tenant's got one floor. I think the tenant would have to look after its own premises, but the landlord would probably need to deal with all the common parts.
Yeah, that's a good point.
Yes, and actually we ourselves have got a real example of this. We had our Cambridge office, which is in a multi-let building, closed for a deep clean following a suspected coronavirus case, and the landlord did close the building to make sure that it cleaned all the common parts, the lifts and so on, to make sure that it was complying with its health and safety duties and generally, frankly, its humane duties to other tenants.
Yeah.
Thank you there. Dave J, has a question for you here. To what extent can a landlord flex the services that it is providing? If there's fewer customers, can we dial back? Are we obliged to continue to provide the services at least commit? Are we allowed to extend those to a deep clean? Do we have to continue to provide the creche, you know, the whole list of landlord services there might be? How flexible can a landlord be as they perhaps wind down a scheme?
Well, the obviously lawyer answer would be it kind of depends on the drafting of the services provision in the individual leases. But in reality, let's be honest, the tenants are going to want it to be flexed. If people aren't occupying, or if they're not trading, or if there's no footfall, I think tenants will be disappointed in their landlords if they carried on sort of going at 100 miles an hour with services for a shopping centre, for example, that anticipates being absolutely rammed all the time. I think tenants will be looking for landlords to be sensible. There will be minimum levels of certain things required. There will be minimum levels of security, for example, that you can't go below. But certainly, you know, most services could be dialed down. Cleaning is quite a good example. Cleaning might well be increased, but that's really sort of a public health issue, isn't it? So I suppose overall, if the centre's, you know, very quiet, then frankly, it doesn't seem sensible to provide a creche. Quite often, you see two schedules of services, particularly in retail, where there's a lot of services provided, where some of them are obligatory and have to be provided, whether that's sort of security, keeping the building in repair, that kind of thing, and some of them are discretionary. I think something like a creche would definitely fall within that latter camp.
Yeah.
Okay. Dave, F1 for you, it looks like. How do we manage renewal proceedings, lease renewal proceedings during this difficult time?
Okay, so just best, you know, we've titled the webinar Practical Solutions. We're seeing both when acting for landlords and investors and also when acting for occupiers, that people are trying to be proactive. And, for example, landlords are accommodating, so far, some requests for extensions to deadlines to issue, for example, 54 applications. The question was a lease renewal question. We're seeing people, consistent with the spirit that Bruce talked about earlier, being more accommodating in that regard. And that also removes unnecessary stress and strain on the relationship, particularly where it's an uncontested lease renewal anyway, and the root of it is essentially consensual. In terms of practicalities, touch on what you said earlier, we can issue where we need to, for example, if there was interim rent applications or other ancillary documents or procedures that needed to be complied with as part of the lease renewal process. We can use electronic documents for quite a lot of that. Things change by the hour. The reality is, at least until this morning, there wasn't sort of electronic filing of court documentation at the county courts. There is at some of the High Court district registries, and there has been, in fact, it's e-issue only in the RCJ in London, and has been for some time. So in terms of how to deal with them, you know, commercially, be accommodating, remember that you can agree things by consent, you can agree to postpone deadlines and extensions by consent. So, you know, it's difficult without knowing the particular dynamic of the lease renewal in question, but that would be my initial response to that sort of question, yeah.
Okay, thank you, David. And one for Bruce. Somebody's picked up on the point you made about giving concessions to tenants in your introduction. You said that didn't compromise the help they might receive from government, or I suppose likely compromise the alternative sources of action from a landlord. How can we be kind to tenants without either you know, compromising our own position as landlord, or meaning that tenants can't fall on government schemes?
So just very quickly, picking up on Dave's points there, that in the room next door to us, we have a virtual tribunal going on with a judge at their kitchen table and barristers presenting remotely from their garages or wherever it is that barristers sit when they're at home. So just picking up on the point about rent concessions, rent concessions are, and indeed concessions in general under a lease, are a very delicate thing, and they can upset the sort of Swiss watch balance that you have within the lease, particularly if you don't get the consent of or pay close attention to the guarantor provisions. You can end up releasing the guarantor of the lease, including any guarantor under an ARGA, and that would be an absolute valuation cataclysm. So one has to be careful when being generous to the tenant, to the actual tenant, that you're not further down the line releasing guarantors and others who actually support the value of your building and its long-term income stream after COVID-19 has long since been dealt with by vaccine and retrovirals.
Thank you, Bruce. Right, I think that's all our questions for now. As I said, we will leave our contact details on screen for now, so if you would like to get in touch with any one of us or your usual Eversheds lawyer, then please do so. So it just remains for me to say thank you very much for joining us today, and to stay safe wherever you may be working, and we will stay online for a moment or two if anybody wants to raise any further questions. Otherwise, I will end the call. Thank you very much.
Thank you, everyone. Stay safe. All the best.
Thank you very much, everybody. Thank you for joining.